Hello, I'm Susheela Varky, domestic and sexual violence attorney for Virginia Poverty Law Center. This is meant as an educational piece of information. This is not legal advice. If you want legal advice for your particular situation, you should talk to an attorney. If you are a survivor of domestic or sexual violence and fear for your safety, so you want to leave your home, you may be worried about breaking your lease. Well, there are certain circumstances under which you can do that without being penalized. One is if you have a full, which would usually be up to 2-year, family abuse protective order. How do you get that? You would go to your local juvenile and domestic relations district court, often called JDR court, and go to the court services unit intake officer, fill out paperwork. Some of that paperwork would include the notice of the full hearing and the allegations that you're saying the person who hurt you did to you. So that paperwork, including the notice and the allegations, would be served on that person who is hurting you. They're called the respondent in protective orders. After that person's been served, you would have a full hearing before the judge. The judge would hear your side of the story, the judge would hear the respondent's side of the story, and make a decision about who the judge believed more. If they believed you more than the respondent, they would issue you a full up to 2-year family abuse protective order. So what does it mean to have family abuse? What is family abuse? Family abuse is an act of violence, force, or threat that results in bodily injury or fear of bodily injury, sexual assault, or death. And that act is committed by a family or household member. So who qualifies as a family or household member? Your spouse, your former spouse, your parents, your children, stepchildren, grandparents, grandchildren, half-siblings, siblings. It would also include in-laws who live in the same house as you, as well as someone that you share a child with. You both have this child together, but you may not have ever gotten married, and someone with whom you had an intimate partner relationship within the last 12 months. And also the child of that person with whom you had an intimate partner relationship who lived in the same household as you. Those are all the people who qualify as family or household members. Another way to terminate your lease early is if you had a conviction of certain types of crimes, certain types of sexual crimes, rape, assault against a family or household member. So you would need to talk to the Commonwealth's attorney in your area to see if the conviction that you have against the person who hurt you is one of these qualifying types of crimes. Once you have that conviction order or the full family abuse protective order, you would go to your landlord and you'd have to write a letter and give that written notice with the letter as well as the order, the protective order or the conviction order, and serve the landlord with your effective date of termination of your lease. It has to be at least 30 days from when your next rent is due. So let me give you an example that I think will help clear that up. So let's say it's June 1st. You write your letter on June 1st. In your letter, you're saying that July 1st, which is 30 days from June 1st, is your effective date of termination. So you would then serve, let's say you serve the landlord with that letter and the qualifying protective order or the conviction order on June 1st itself. You're good, and your written letter of notice saying July 1st is your effective termination date is fine. But if you're only able to serve the landlord on June 2nd or some other day in June, That's not going to be a full 30 days until when your next rent payment is due, July 1st. So your effective date of termination that has to be in your written letter too would be August 1st. Hopefully that makes sense. What does it mean to serve your landlord? So if you're used to hand delivering your rent or just putting it in the mail, US first class mail, that probably is not going to qualify as proof that you've served your landlord. You should hire a process server, private process server, to serve the landlord, or you can send it certified mail. That would give you a receipt of when it was received. So you are going to have to take that into consideration when writing your effective termination date in the written letter that you're going to serve on the landlord. Remember, you're serving both the written letter with your effective date of termination plus either the full family abuse protective order copy or a copy of a qualifying crime conviction order. So hopefully that helps you. And this is meant as an educational piece of information. This is not legal advice. If you want legal advice for your particular situation, you should talk to an attorney. Thank you so much.